Shweta madam, all set?
Yes, ma'am.
Okay. Savita, permission, should we?
Yeah, thank you, ma'am.
Good morning and a warm welcome to all the participants present here for the final day of the session of this virtual series on IB case studies, case laws. And it is indeed a pleasure that everyone joins at sharp 8 a.m. for this virtual series, all those who are preparing for these exams. And today we have with us CA Dr. Gopal Krishna Raju sir, who had started this session on day one. He is a practicing chartered accountant and also an insolvency professional and a registered valuer. Sir has been awarded the honorary directorate in the governance of GST in government sector by St. Mother Teresa University, Melbourne, Australia. Sir's achievements and accomplishments are really very great. But to introduced specifically, sir is a prolific writer and a speaker at various forums, appears on various media channels regularly, and basically his inclination and liking is towards technology and taxation. So on these subjects as well, sir has authored various books. At the same time, sir is regularly writing in the newspapers, daily columns. So with this achievements and accomplishments over past few decades in the profession, definitely with the treasure trove of experiences gathered in these domains, sir will help us all for preparation of these exams. Without taking much of the time, I request CA Dr. Gopal Krishna Raju sir to please take over the session, and the stage is all yours, sir. Welcome.
Thank you, ma'am. Thank you. Thank you. A very good morning, friends. At the outset, let me thank Pune branch of Western India Regional Council for this excellent opportunity, especially on the special topic of Insolvency and Bankruptcy Board of India's limited insolvency examination. Exclusively designed a program for those who are appearing for this LIE exam, limited insolvency exam. I must compliment Pune branch for one reason. Very boldly, normally the branches, they don't put those information. They have very boldly made a poster that there is no CPE, and despite no CPE. So the kind of support for this program from various parts of the country, or I must say it's phenomenal. So it is not the numbers of participants that matter, but the commitment of the participants, number two. And we strongly believe that all the participants who are going to appear for examination, maybe in very soon, either many they are going to appear for this month. So our best wishes to them. And we are going to hear various news with respect to participants clearing this examination with flying colors. So that is what Pune branch objective is. So this program is a milestone in the Pune branch program. So I appreciate the efforts of the branch, and more such programs also in the future they have to do. Coming to today's topic, this is actually a very, very big topic. I must say quite a large topic actually. Before I venture into this topic, I must tell you why I call this as a large topic. Please look at the entire structure of this syllabus. We have actually 258 sections in Insolvency Bankruptcy Code, but out of that, Part 3, actually there are 4 parts in IBC. So out of these 4 parts, part 3 is almost more than, it's 101. It's actually 100 sections. So not 199 sections. So that means out of 258 sections, so almost 100 is one chapter. So out of 4 chapters, 1 chapter is 100 section is quite a big one. So it starts from 78 and goes up to 187. So it's we can say it is 110 sections. Okay, it's exactly 110. So that is the size. So in terms of percentage, maybe number if you take, so it will be almost 40, more than 40% of the pages of the IBC is in this particular part. Now, out of this, the chapter 2 alone, I will not be discussing because this is one topic may not be asked in examination, even though it is included in the syllabus. Okay, the fresh start process is not yet been notified. Okay, so it is not yet notified. So academically, you want to learn, you can learn, but you can ignore. So it is not. So this seems to be it will be included in the examination, but since not notified, we'll ignore it. Okay. So that is why part 3, chapter 1 to 7, except chapter 2. So chapter 2 is fresh start process. Now, out of this entire sections, we already know that I just want to bring to your attention 70. Yes. So this is your part 3. It starts from 78. Now look at 79. 79 is definitions. This particular code has actually 3 definitions. So one is section 3, which is a general definition applicable for the entire code. Section 5, which is a definition applicable for part 2. Section 79, which is a definition applicable for part 3. In this part, unless the content otherwise requires. So these are definitions pertaining to chapter 3. So I will take you through some of the important things. Now, let me bring to your kind attention. Yeah. This is the 15th of November 2019. There is a very important notification. That notification is important because this is the notification which has kick-started the chapter 3. So far, chapter 3 was not part of the system. It was only academic. So when I was a student of IBC, part 3 we used to study as an academic chapter, not a practical chapter. So now post 2019, you have this as a practical chapter. Now please look at this section, which is very relevant. In exercise of powers conferred under 1.3 of the IBC code. So I want to bring to your kind attention the code. I will keep it parallelly, and the chapter 3 I will keep it parallelly. Okay. So let me take you the code. So this is your code. So I will. This code is as on amended up to 12/8/2021. So I will take the 12/8/2021 up to this is the code. This is what is applicable for your examination. Now, if you look at this, it shall come into force on such a date as the central government may by notification the official gazette appoint. provided that different dates may be appointed for different provisions of this code. So that is why I want to bring to your kind attention. This 1.3 says different provisions. Okay, sorry. Different dates may be appointed for different provisions of this code. Okay. So now I'm coming for the different provisions. Okay, what are those provisions? So first is 2E. So I want to first start with the section 2E, 78, 79. Please look at this. Except with regard to fresh start process. So they have made it very clear. So that is why I said, even though in the syllabus they will say insolvency bankruptcy code totally, this has not been notified. So therefore, you ignore it as far as the syllabus is concerned. Okay, I mean for preparation of examination is concerned. Now this is your section 2, and look at E. Actually, we originally had A, B, C, D only. E, F, G was not there. Okay, so E, F, G was inserted when it was inserted 23/11/2017. So 2E, 2F, 2G, all these were inserted as on 23/11/2017. Now, what is this 3 that was inserted? They say the provisions of this code shall apply to, of course, company is fine, LLP is fine. Okay. Will it apply to personal guarantors to corporate debtors, partnership firms and proprietor firms, individuals other than the persons referred to in class E? Because personal guarantor is a individual. For example, a company has borrowed loan from a bank. Company has borrowed loan from a bank. Maybe they would have given some collateral. The collateral belongs to the company. But the director or a shareholder or the promoter as an individual would have given a personal guarantee also for the loan borrowed by the company from a financial creditor. Now, if the corporate debtor fails to make a payment, for example, the amount is 400 crores. 400 crores is defaulted. Now, personal guarantor, maybe if they proceed against the company, they will get only 120 crores. 400 minus 120 is 280 crores. Now, personal guarantor, there is a guarantee given for 50 crores. Why should I leave 50? Can I proceed against the personal guarantor? Yes, you can. Okay. Because personal guarantor is an individual. Now, how do you proceed against a personal guarantor? So, personal guarantor to corporate debtors, they have brought a separate notification in the same date. So, this is your date. Sorry. This is your 15th of November 2019, but this is applicable from 1st of December 2019. This notification came from 15th of November, but applicable from 15th of November, no, it is applicable from 1st of December only. Look at this. Hereby upon the first day of December as the date of the following provision. And on the same 15th of November, sorry, on the same 1st of December, they have brought 2 more. Okay, 2 more they have brought, which is insolvency and bankruptcy, application to adjudicating authority for insolvency resolution process for personal guarantor to corporate debtor, application to adjudicating authority for bankruptcy process for personal guarantor to corporate. This is insolvency resolution process. If it fails, bankruptcy process. So both. Okay. Now please come to the next one. On the same date, they have also brought the regulations also. So now you have 2 rules. One is a insolvency resolution process rules against corporate debtor. Another rule is bankruptcy process for personal guarantor. Third, insolvency process for personal guarantor regulation. Fourth, bankruptcy process personal guarantor for bankruptcy process for personal guarantors for corporate debtors regulations. Okay, so now you have 4 things, so that I have to change it. So it is not rules, it is regulation. So let me now take those 4 items before you. This is your rules. So if you look at it, so this is your 15th November. Insolvency bankruptcy process, application to adjudicating authority for bankruptcy process or personal guarantor. Open. This is bankruptcy process. So I will be referring these rules now and again through my questions. So please wait for my questions. Similarly, you have the insolvency resolution process rules. Yes, this is the insolvency resolution process rules. This is where these rules may be called as the insolvency and bankruptcy. So remember, normally rules will be brought by the insolvency and bankruptcy, and regulations will be brought by IBBA. Okay. So now I'll take you to the regulation. So here, we have this regulation. So look at this. So this is your IBBI insolvency resolution process for personal guarantors corporate regulation. Regulation runs for 12 pages. My God. Okay. Similarly, insolvency, IBBI bankruptcy process of personal guarantor corporate regulations. So this is your regulation. Hindi chhod denge. Now I'll take you to English part. This is here. Okay. So notified on 20th November. Okay. All coming into force from 1st of December. All the four. Okay. So where is it? These are the four items. So one is where, so this is where insolvency resolution process rules. This is your bankruptcy process rules. This is your insolvency resolution process regulations. Okay. Now this is your bankruptcy process regulations. Good. So all these four are applicable from 1st of December 2019. Okay. Good. So where I am? Right. This is 2.8. And section 94 to 187 both inclusive. Now look at this section. 94 to 187. So, sorry. 78, 79. Except with respect to fresh start. So 78, 79, 194 to 187. It is applicable. So this is applicable. Okay. This is applicable. And all these are applicable. So except fresh start process. So what I will do, I'll put this red color. This is not it. So that alone is not applicable. So chapter 1, 3, 4, 5, 6, and 7 are applicable. So now I go into the subject. So where and all you have to give a reference, I will take you through. Okay, good. So then class 239 21G, class 239 2ZCM, class 240 ZN 2ZN to ZS, 2M to ZC, and class 249. Now what is this? These are the class that give rights to central government to bring the rules and regulations. Okay, I'll just take you through those sections. Okay, one by one. Wherever you have a queries, you can raise your hand. We will unmute you and you can ask questions. Okay, good. So now, let me take you to, yes. So this is your section 239. Let me take you to 239. This is your 228, 239. 230. Now look at 239. Power to make rules. Now here, what did it say? Is 239 to GHI. Okay. To G. This is with respect to 79. H, unencumbered single dwelling unit. I'll come to this because they have given a notification with respect to unencumbered single dwelling unit. I'll come to that. Okay. Then the value under clause C, any other debt under 7914. I'll come to these. I'll explain this through questions. So please wait. So GHI has been notified. Okay. And apart from that, 239 to ZC. Okay. What is ZC? This is ZC. The particulars which the notice shall contain. So for all these rules have been made. Okay. And look at 240. This is power to make regulation. So I'll take it to Zn. Look at Zn. And this is Zn. GHIJK. There. 95. Details and documents. And it goes on. So all the sections for which the up to ZS. The fees to be charged under 144. For everything, the regulations has been framed. All these are with respect to rules and regulations. Excellent. So now let me take you into the subject. Okay, good. Now we need to understand this very clearly. For corporate and non-corporate, the moment you say non-corporate, you have who are they? I'll just take a list here. You have 2E. Okay. So you have 2E. Then you have, sorry, 2E, 2F, and 2G. So these are the three sections. Actually, what is 2E? Your 2E is here. Personal guarantors and corporate. Personal guarantors to corporate debtors. Guarantors to CD. Now come to 2F, partnership firms and proprietor firms. So firms, partnership and proprietor. Okay. Look at this. It is not been notified for your information. F is not notified. Individuals other than 2E. Individuals means other than personal guarantors to corporate debtors, other individuals who have not given personal guarantee to corporate debtor, maybe they would have borrowed individually. Okay, for them it is not applicable as of today. So now come to this part. When I say non-corporates, these are called non-corporates. These three are called non-corporates. Okay, these three are called non-corporates for your kind information. Now here, for corporate, you have the insolvency process. Non-corporate also insolvency process. So there is an application to be made. There's a lot of difference between insolvency process for corporate and non-corporate. A lot of differences there. So let us discuss those differences. And in corporate, if resolution fails, liquidation. For a non-corporate, resolution fails, it is not liquidation. It is bankruptcy. It is bankruptcy. So in corporate, the role of IP, it takes different avatars. In insolvency process, first 30 days honeymoon period, IRP. Then he becomes RP. Maybe if the process fails, he becomes a liquidator for liquidation process. In a non-corporate, for bankruptcy process, he is called bankruptcy trustee. So look at the various avatars. Okay, good. So bankruptcy is a process equivalent to a liquidation process. Okay, good. So now let me start with this first question. Okay. So all of you please pay attention. So I'll now take you to chapter 3. Chapter 3, here and there, I will also refer to the definitions part also, because many places I will come to these definitions one by one. Actually, in this definition, if you look at this, you will be quite surprised. Okay. So they have actually included this many things in bankruptcy. Okay. So I just want to bring it to a candidate. Look at this caution. So bankruptcy debt, bankruptcy commencement date, bankruptcy order, bankruptcy process, bankruptcy trustee are separately defined in section 79. Look at this. What is bankruptcy? Bankrupt. It starts from bankrupt. So it is 79.3. Okay. So it is 79.3. Bankruptcy. This is 79.4. Okay. What is bankruptcy debt? 79.5. These can be exam question, guys. Okay. And whenever you are getting case studies also on this, based on this only case study also will be connected. Okay. Then 79.6 is bankruptcy commencement date. So there you have the liquidation commencement date, insolvency commencement date. So here it will be bankruptcy commencement. Here also you have this concept of the insolvency commencement date. Here also it will be there, but you have a separate date called bankruptcy commencement date. There is no concept here called liquidation commencement. Bankruptcy order, so 7. Okay. Then bankruptcy process, 8, bankruptcy trustee 9. Okay. 79.8, this is 79.9. So these are separately defined for your kind information. Okay. So all these are separately. Bankruptcy debt, bankruptcy commencement date, bankruptcy order, bankruptcy process, bankruptcy trustee. So I'll take one by one. So please wait. Now, who may apply to initiate insolvency resolution process for an individual or partnership? Now, all these questions you have to only understand from a corporate, from a personal guarantor to a corporate debtor. So I already made this point very clear. Personal guarantor to a corporate debtor. So only 2E has been 2E alone has been notified for your information. 2E alone has been notified. This is not notified. So this is also not notified. So therefore, only this is applicable. Personal guarantor to CD is only applicable. These two not yet been notified. So can I file an application against a partnership firm? Can I file an application against a proprietor firm who is a sole the owner is a sole proprietor? Can I file an application against an individual? But can I file an application against an individual? Okay, this is an individual. Personal guarantor. Personal means individual. Okay, personal guarantor means individual. Actually, I want to start with this definition actually. So, is the word personal guarantor defined here in part 3? So I want to bring it to your attention here. So nowhere they have defined here. So, but they have defined this word personal guarantor in 3. So what I will do, I will take you to 3. So this is your section 3. This is section 3. Here they have inserted certain, they have brought new definitions. Okay. So let me take you to personal guarantee. Okay. So this is coming under section 3 or 2 5 5. So this is coming under 522 PG. Okay. So let me take you to personal. Now personal guarantor means individual. Please. That is why I made this point here. Personal guarantor means maybe I'll remove this individual. I'll put this here. He's an individual. Personal guarantor is an individual. Look at this. Sorry, where am I? Personal guarantor is an individual who is a surety in a contract of guarantee to a corporate debtor. Who's a surety. Okay, he has assured. So when the corporate debtor fails, I'll initiate action. Now, how to initiate action? Okay, now here the personal guarantor, can he be a partnership firm? No. Can he be a proprietorship firm? No. Okay, so it is not possible. Okay, good. So now let me take you to this section 94 and 95. Okay, so where is 94? This is fresh test start is not applicable. Entire section not. So straight away I'll go to the insolvency resolution. 94. Remember, guys, 94 is application by debtor to initiate insolvency resolution process. 95 is application by creditor to initiate insolvency resolution process. So now please understand some fundamental difference. In chapter 2, chapter 3, in chapter 2, in part 2 and part 3. In part 2, it is CIRP. It is a corporate insolvency resolution process. Okay. So corporate would have, company would have borrowed money. And when he defaults, he becomes a corporate debtor. Now here, an individual who has given a guarantee to the corporate debtor, an individual was given a guarantee to a corporate debtor. Now, when the corporate debtor fails to make payment, and maybe they may initiate action, they may initiate a CIRP to the corporate debtor. They may not initiate CIRP to corporate debtor also. Please understand, two situations. So, situation one, they initiate CIRP. Can they initiate CIRP against the, what do you call it as, can they initiate the insolvency resolution process against personal guarantor? Please wait. Initiating an insolvency resolution process against a personal guarantor can be done only when he defaults. So, for example, now the company fails to make payment. So then I will ask the payment from the guarantor. Now, guarantor fails to make the payment after making an effort by the financial creditor. Then only he will initiate again. So I cannot directly go to my lord, personal guarantor is not making payment. You should ask personal guarantor. And personal guarantor will say, no, I will not pay. Then you initiate action. So this is very important step. Okay. So now he becomes then debtor. Only when, so financial creditor must ask and to the individual, personal guarantor. So personal guarantor, when he fails to make the payment, he becomes a debtor. Okay, see the avatar. So various avatars are there. So you have to be very careful. So this individual, this fellow is very simple guy. Now this individual is giving guarantee, surety, guarantor. That means he is a surety. Now, so individual, he has not given guarantee. Now the individual, he has given a surety to a, okay, to a company, then he becomes a personal guarantor. Now, financial creditor will ask personal guarantor to make payment. When he fails to make payment, okay, when he fails to make payment, personal guarantor will become debtor. Okay, personal guarantor will become debtor. Now this debtor, so all three are same only, same guy only. All three are one and the same. Okay, so let me say GKR. Okay, GKR. Sorry. So GKR. So I take avatar of individual. The moment I give surety, I become personal guarantor. The moment the financial creditor asks payment, I fail to make payment, I become debtor. Now 94, 95. Now 94, application by debtor. I can make an application. Or creditor may make an application. Shankar Rao is asking a question. Oh, Shankar Rao. Let me unmute Shankar Rao. Shankar Rao. Where is Shankar Rao? Yes, Shankar Rao. What is your question, please? Please,
For this creator means,
please introduce yourself. Please introduce yourself.
sir, I am Shankar Rao, sir.
From?
Sir, from NESL.
From?
NESL, National E-Governance Services Limited.
Oh, National E-Governance Services Limited. Okay, so which place of India you belong to?
Chennai.
Chennai. Okay. Go ahead, Mr. Shankar Rao.
Sir, this creator only we are asking. Creator only you are telling me. Creator means it includes both FC and OC, sir, operational creditors and financial creditor. So anybody can initiate.
Super question, Shankar Rao. Super question. Now, when there is a movie directed by Shankar, you are Shankar Rao, so I am saying Shankar is a very popular director. He directed a movie called Onion. In that, Onion will be a bad character, then Ramanujan will be a good character, then Remo will be another character. When you are in CIRP, be like a Remo. But when you are in this personal guarantor, you should forget that. You should forget that character. This is a different character, same act only, but different character. So here, creditor doesn't mean only financial creditor. Here, creditor means operation creditor and financial creditor. Very interesting word. Shankar Rao Garu. Thank you very much.
Thank you, sir. Thank you.
So now I am coming to this. Who may apply to initiate the insolvency resolution process? IRB. Okay. So, who may initiate the insolvency resolution process for a individual or a partnership? Actually, I will ignore this word partnership because not applicable as of today, but I will take individual. Now, who is this individual? Individual who is a personal guarantor who has failed to make the payment to the financial creditor even after asking the payment, then he becomes a debtor. Look at the avatar. Individual, personal guarantor, then he becomes a debtor. So, who may apply to initiate insolvency? By the debtor, through a resolution professional, by the creditor, by the debtor, or by a creditor, or through a resolution professional. Now, I will take you to this 94.1. A debtor who commits a default, look, this is very important. Who commits a default means financial creditor should ask, hey, you have given surety to ABC Limited. ABC didn't pay, you pay. Now, will you pay is the question. If you pay, no action. You are a very good guy, very good boy. Okay, now you don't pay, then you commit a default. You commit a default after asking. Then a debtor may apply. Debtor means he committed default. He himself can apply. My lord, please help me. People are behind me. So I can apply either personally or through a resolution professional. This is the twist. Please note down this. Use a pencil, pen, everything and note down this. Never compare this with the CIR. CIRP is different. I will say the individual resolution process is much above CIRP. Actually, everybody should have been taught first these sections only. Then only CIRP should be taught. Unfortunately, we read CIRP first, then we come here. So we always compare with CIRP. So you should first be introduced to Maheswara. Lord Maheswara only is big. Then only we should introduce to Parvati, then to the Ganesha, then to Muruga, then one more family member is there, Ayyappa. Ayyappa also is an offspring of Lord Shiva only. Okay. So we should not introduce first to Ayyappa, then I should not introduce to Maheswara. Maheswara is first. This chapter 3 has to be studied first. Okay. So a debtor who commits a default may apply either personally or through RP. This is not there in CIRB. So you can make a connect from here to there, but don't make a connect from there to here. Okay. These are absent like that. Now come to this 95. A creditor may apply. Now there is a difference between 94.1 and 95. Now in 94, debtor who commits a default only can apply. Now, I don't have money. So then he commits a default means there should be a proof. Similarly, a creditor who may apply may apply either by himself or jointly with other creditor or the resolution professional for initiating. But remember, even creditor, when he is applying, either himself or jointly or the resolution professional, he needs to tell my lord, I asked money, he didn't pay. So therefore, insolvency resolution process. So therefore, default is fundamental. Okay. Then only he becomes a debtor. Who is a debtor? Look at this definition. Okay. So the word debtor, debtor is defined actually. So this is 7912. Debtor includes judgment debtor. That's all matter over. Actually, debtor is not defined. It's only inclusive definition. Debtor means somebody who is not paid money. That's all. So look at 95 for your information. You have to interpret it very, very carefully. Okay. A creditor may apply either himself or jointly or the resolution, initiating insolvency resolution process under this section. Now, against whom? Against debtor only. Okay. So in the application form, which I will be showing the personal guarantor rules, personal guarantor regulations. There, the word debtor will be used. For example, now come here. So this is your IBBA regulations. This is your IBBA regulations. This is your insolvency and bank application to adjudicating authority for insolvency resolution process rules. So here, application is there. Now come to the application form. This is the form. Okay. Form means form appended to guarantor. Okay. Guarantor means a debtor who is a personal guarantor. Look at this, guarantor. Okay. So I'll now come to the form. Look at the form. Application by guarantor to initiate. Okay. Application by guarantor. Guarantor. Okay. So guarantor is whom? The individual. Look at this word guarantor. So where is it? Guarantor means a debtor. Guarantor is a debtor. Now who is a debtor? Debtor is a guy who has defaulted. Okay. Debtor includes the, what you call the judgmental debtor. Okay. Adjudicated. Okay. So we have this definition here. So who is your debtor? Definition. So 7912. Look at 7912. So judgment debtor. Okay. So you have to be very careful with these wordings. So application by guarantor. This is form A. Now come to okay. This business particulars of guarantor. Okay. So now this section. These are all the attachments. This is form B. Form of demand notice. Okay. So now this is form C. Application by creditor to initiate insolvency resolution process. Okay. Now rule 7.2. I'll come to this rule a little later. Very interesting rules. Now here they don't mention it is financial creditor. It is operation creditor. Creditor is a creditor. Okay. So whether it is operation creditor or financial creditor, if he doesn't pay, he can initiate. Doesn't pay. So therefore, the word here that will be used, this is particulars of applicant. Okay. Now, particulars of the guarantor. Now, who is a guarantor? Guarantor is a debtor. Now, who is a debtor? Debtor is a guy who defaults. Now, who is a guarantor? Guarantor is a guy who has actually given a, so individual who has given a surety to the corporate debtor. Now, company doesn't pay. So, can I initiate against the guarantor? Yes, you can. So, this guarantor is a very important word. So, guarantor is a debtor. Who is a debtor? Debtor is a personal guarantor who is an individual who has given surety to the corporate debtor. So, this many avatars are there. You have to be very careful. Good. So, now come to this question. Who may apply? So, it is a debtor or creditor or the resolution profession. So, 1D. Now, come to the next one. Now, henceforth, we can go much faster. The application to initiate insolvency resolution process by debtor who is a partner in a firm. Actually, these kind of questions may not come, but anyhow, since it has not been notified, I'll ignore this question. Okay. So if it is a partner in a firm, maybe I'll answer this question because 94.2. If it is a partnership firm, who has to sign? Look at 94, I'll go to subsection. When the debtor is a partner in a firm, such debtor shall not apply unless all or majority of the partner of the firm file jointly. Okay, so that means if there are 5 partners, 3 have to sign, or all 5. Okay. All partners apply, or majority of the partner apply jointly. Only if all partners consent, not required. All partner only, applicant only. By the partner applicant, not possible. Only if all partners witness the application. That is also not correct. All partners apply, 5 partners, all 5 should sign, or majority, 3 should sign. Okay, good. Now let me come to the next question. Now, there is a lot of difference between your CIRP and your individual insolvency, that is your personal guarantor insolvency. So one major difference is this interim moratorium. So I'll just take you to 96. This is the interim moratorium. Now, moratorium is applicable from the insolvency commencement date for a corporate insolvency resolution process. Here, from the application date to the admission date, there is an interim moratorium. Then from admission date, moratorium starts. So look at this. You have a section 96 called interim moratorium. You also one more section which is called as moratorium. This is admission, then moratorium. Okay. So please understand the fundamental difference between 101 versus 96. 96 is interim moratorium. 101 is moratorium. Okay. Now, when an application is filed under 94/95, an interim moratorium shall commence on the date of the application, provided application should be dated, okay, by the registrar of the National Company Law Tribunal. Okay. So because you don't have a debt recovery tribunal, because partnership firm, proprietor firm, individuals presently are not notified. That is, 2 FNG is not notified. Only personal guarantor or corporate debtor is notified. And what is applicable? Okay. I must tell you what is applicable. Who is actually the adjudicating authority? The adjudicating authority for personal guarantor, I want to bring it to your kind attention here. So this is your insolvency and bankruptcy application to adjudicating authority for insolvency resolution process for personal guarantor to corporate debtor. Now, who is this adjudicating authority? Okay, come to this adjudicating authority. Okay, for the purpose of section 60, very important, very, very important, 60. So I will now take you to section 60. Look at 60. This is your 57. Look at 60. This is 60. Look at 60. Now here, the adjudicating authority in relation to insolvency resolution liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be the NCLT having jurisdiction over the place where the registered office of the corporate person is located. Now, I am Gopal Krishna Raju. I am in Chennai. I have given a guarantee to a company which is having registered office in Mumbai. Now, that company failed to make payment to a financial creditor, which is Bank of Baroda. Now, I have given a surety to that company in Mumbai. Now, Bank of Baroda, can they file an application against Gopal Krishna Raju, who is a personal guarantor, who has become a debtor because I have failed to make payment to Bank of Baroda? Because company hasn't failed, they have initiated a demand on me and I have not paid that demand. So I am a debtor. Okay, I have defaulted, so I am a debtor. So now can they initiate action against me? Now, which NCLT they will file? Chennai, because my residence, my office is in Chennai? No. Registered office of the corporate person is located. These are all case study questions. Please understand. So the question will be like this. So and so. Now application should be filed. NCLT Chennai, NCLT Mumbai, NCLT Bengaluru. Anywhere, any NCLT you can file. All these questions will come. Okay. So where am I? Now interim moratorium. Where am I? Interim moratorium. So interim moratorium from the date of application and shall cease to the date of admission. So application date to admission date is interim moratorium. Now, what is interim moratorium? Same moratorium. You cannot file an action against, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. Creditor shall not initiate any legal action in respect of any debt. This is very important. If somebody is threatening you, immediately go before, my lord, please help me. These guys are going to bring action. Okay. So there are certain things I cannot tell openly in this recorded forum. Certain things I can only tell which is not recorded. Okay. People use this as a very important protection mechanism also. Okay. Good. So now interim moratorium under insolvency resolution process for non-corporates under 96 shall be valid for 90 days. Valid for 180. Commence on the date of application, cease on the date of admission. Commence on the date of application, cease 90 days. So see one. So it commences on date of application, cease on date of admission. Okay. Good. The adjudicating authority order. Admitting application shall be. So now let me take you to, this is where, actually this section is a very, very important section. Okay, there is a report of submission or report by resolution. It's a very, very important section. Something very crucial actually. So once the application date and the admission date, before application and admission, there is a report to be submitted by RP. Very important report. This is not there in CIRP. That is why I said this process is much bigger. So rather than introducing you to Ganesha and Lord Muruga and Lord Ayyappa, first Maheshwara should be identified. Maheshwara is a gigantic Lord. Okay. So this is what do you call it as? Part 3 is very big. Submission or report by resolution professional. Very, very important. For the separate fees. Now, who will pay fees for this question and all? There will be a case study question. Who will appoint this? Because submission or report by RP. Who will select the RP? This report, for this report, there should be some fees. Who will pay these fees? Okay, very interesting question. Okay, I'll come to this because 99.1 to 99.10. 10 subsections are there. Read this 10 subsections. Very, very important. Okay. This 100 admission or rejection application. Look at the adjudicating authority shall provide a copy of the order passed under 1 along with the report of the RP. This is very important. And the application to the creditors within 7 days on the date of order. Who are creditors? The creditors which are mentioned in the application and which is confirmed by the report by the resolution professional. Sometimes they may give a list of creditors, only 7. But the resolution professional should confirm this 7. That is why this report is very critical. And there is so even before you start your resolution, a resolution professional makes a start. There is important work. This work is very, very interesting. Okay. So adjudicating authority admitting application shall be communicated to the creditors only on a standalone basis. Communicated to debtor only. Communicated to both debtors and creditors. Communicated to creditors along with the report of the resolution professional. Along with the report. Very important. Look at this. So shall provide a copy along with the report of the RP and the application to the creditors within 7 days. Because that is because the report of the resolution professional will be given to the creditors. In that creditor's name will be there. And the amount also will be there. He can then make a claim. No, what you said is wrong. It is less, it is more. That and all will come. Quite interesting point is this. So that is why lot of debate. Actually, this part 3, I will say, is much robust, much very, very scientific, very scientific. I don't know why these methods, and part of this model is only being used in PPIRP also now. That is a pre-pack, okay, insolvency resolution. So quite, so this is most robust mechanism which they have designed in the IBC. Quite interesting model. So it is 4D. Good. Now come to 5C. Moratorium. No, moratorium is 101. Interim moratorium is 96. So gap is only 5 sections. No, come to 101 moratorium. This moratorium will be for how many days? See, there moratorium is actually you have 270 days. Okay. So 60, then you can extend it. All these things is there. So maximum it cannot go beyond 270 days. Now here, moratorium, okay, shall commence and shall cease to have effect at the period of 180 days, beginning from admission date. Okay, or even earlier date. So either 180 days or earlier date. So compulsory 190 days wrong. Compulsory 180 days wrong. Period of 180 days or the date of passing of 114 order on the repayment plan. There it is resolution plan. Here it is called repayment plan. Okay, RP. Resolution plan, repayment plan. There also liquidator, here bankruptcy trustee. So there only moratorium, here moratorium and interim moratorium. So like that you have to make connecting points, and you will feel these prescriptions are much robust compared to a CIRP prescriptions. Okay, good. So that is your 5C. Come to these are all public notice. Many things I will not discuss. I will now take you to I think this one bankruptcy order. This is a very, very important questions. Look at 26, section 26. An individual who is a surety. Actually, we discussed this in, I think we defined it in section 5. Section 522. This is 22. An individual who is a surety in a contract of guarantee. So, surety, contract of guarantee, he should be an individual. Okay. Contract of guarantee to a corporate. Contract of guarantee to a corporate. Who is a surety? He is an individual. He is a guarantor or corporate guarantor, personal guarantor, stakeholder. Guarantor is a very general term. Okay. This guy is called personal guarantor. Guarantor is defined in the rules. Come to rules here. This is your bankruptcy process. This is your insolvency resolution process. Here they have defined the word guarantor. Now, in the code, they have defined 522. They have defined personal guarantor. In the rules, 31G. 31G rules, they have defined guarantor. So, personal guarantor 522. Guarantor means a debtor who is a personal guarantor. So, personal guarantor 522. Debtor. Now, who is a debtor? Debtor is a guy who has defaulted. Then he is called as a guarantor. Means so debtor, guarantor, you can use it. Okay. Debtor means that. The guarantor means debtor. Okay. Who is a personal guarantor, and in respect of guarantee has been invoked. Very, very important. Look at this word. In respect of guarantee has been invoked by the creditor and remains unpaid in full or in part. Now, 50 crore guarantee I will invoke. Out of 50 crore, 10 I will pay, 40 I have not paid. Then even then he is a debtor. Then I will, okay. So in respect of guarantee has been invoked and remains unpaid. So he is a guarantor. He is a debtor who is a personal guarantor. So this is very important. Guarantee has just been invoked. Okay. These things are not discussed in code. It's only discussed in rules. Okay. So now, so an individual who is a surety means personal guarantor. So 26C. Good. Now come to the next one. A corporate person who is a surety in a contract of guarantee. An individual who is a surety in a contract of guarantee is a personal guarantor. A corporate person who is a surety in a contract of guarantee to a corporate. Corporate person to a corporate debtor. Individual to a corporate debtor. Individual surety to a corporate debtor. Corporate person surety to a corporate debtor. Naturally, he cannot be personal guarantor. Guarantor definition we already saw. 21G. So by elimination, he should be a corporate guarantor. So let us see. So where is it? This is corporate guarantor. Corporate guarantor. This is 5A. 5A. PG personal guarantor. CG corporate guarantor. So corporate person is a surety in a contract of guarantee to a corporate. Now, if a corporate person that contract of guarantee is invoked and if fails or he fails to pay fully or in part, then the corporate person will become a corporate debtor. Okay. So look at these wordings. So personal guarantor will become a debtor. And the corporate guarantor will become a corporate debtor. Now, once he becomes a corporate debtor, CARP can be initiated. So the guarantor can be an individual, a personal guarantor can be a corporate guarantor. So the personal guarantor or corporate guarantor, once the guarantee is invoked, fails to make fully or in part, so personal guarantor will become debtor or corporate guarantor will become corporate debtor. Then CARP can be initiated. Okay, good. So this is 27B. Good. Oh, a debtor who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or in part is a guarantor. Just no visa. So 28A is a guarantor. Now, where is it given? Rule 31E. Okay, not 31E, it is 31G, if I'm right. 31E, sorry, not G. 31E, correct. 31E. Okay, so this is actually a guarantor. So 28. So now I am coming for something very, very important terms. Okay, so let me now take you to this is a very important now personal guarantor. So what I will do, I am GKR, I am a personal guarantor. I failed to make payment because on revoking of the guarantee. Now, GKR. Okay. So I have certain assets. Okay. So what are those assets? Okay. So land and building. Okay. Car, two-wheeler. Okay. PPF, equity. Okay. NPS. So many items are there. Okay. So these are all my assets. Now I given a guarantee. Okay. Land and building, let us say 85. All these are in lakhs. Okay. Car, 15 lakhs. Two-wheeler, 2 lakhs. PPF, 10 lakhs. Equity, say 15 lakhs. NPS, say 10 lakhs. Okay, these are all my assets. Jewelry. My jewelry. Okay. So jewelry in my name. Okay. So jewelry is, let us say 15 lakhs. Okay. Good. So now, I will now take this total. I would have signed all the papers. He is given some papers. So chuck, everywhere I sign. Okay. Take it. Okay. So keep the change. So like that I sign it and give. Now this much worth of assets are there. So this is 152 lakhs. I have given a guarantee for. Okay. So why in lakhs? Anyhow, just like that only I'm putting. Let me put it in crores. Okay. Some amount in crores. I given a guarantee for 200 crores. Okay. Let us say 120 crores I have given a guarantee. I have assets worth 152 crores. So, oh, very good. This is a very good guy. 152 crore net worth. This is my net worth. Okay. Can I give a guarantee for 120? Yes, I can give a guarantee. Now come to this. Now he is invoking guarantee. What is the word? He is invoked. The guarantee has been invoked by the creditor and remains unpaid in full or part. Fully I have not paid. 120 crores he has invoked. I am not paying in full. Now, whether on all these he will have. Okay. So that is where this question is very important. So now what I will do, I'll take you to 79. This is 79. In this 79, the definition, we have 14 excluded. Okay, 79:14 is very, very important section. Okay. Now here, excluded assets for the purpose of this part includes. Okay. So now, in my office, I have my books, my professional books, which is professional books slash my equipments. Computers, television, TV, everything, and table, furniture, all these, all are my equipments only. So that is around 5 crores. Wow. Now come here. So unencumbered tools, books, vehicles, and other equipments as are necessary to the debtor. Bankruptcy, after insolvency process doesn't work, then he will become bankrupt. So bankrupt for his personal use or for the purpose of employment, business operation, it is excluded. So out of 157 crores, 5 cannot be touched. Okay, cannot be touched. I'll come down below. We cannot touch this 5. This is excluded. Okay, this is excluded. Okay. Now come here. Unencumbered furniture, household equipment. So tools, books, vehicles. So tools, books, vehicles are also there. Okay. So what I will do, this is professional books. This is my vehicle. This also you cannot touch. Yeah. So 5, 15 plus 2. So 22 crores you cannot touch. Okay. That is it. Furniture you cannot touch. Household equipment, provisions as an necessary satisfied. So furniture, land and building, I will put furniture. So furniture is, let us say, some 8 crores. This also you cannot touch. Okay. So this is my net worth. Guarantee I given for 120. I have to exclude that. So from the net worth, less excluded assets. Okay. So originally it is 55, 135. I got a guarantee for 120. Okay. So now let us go for the next one. Any unencumbered personal ornaments of such value as may prescribed, which cannot be parted in account of religious usage. Okay, religious usage. This is my jewelry. Okay, these are all my jewelry which has been gifted on my marriage. On the occasion of my marriage. So this is very traditional. Okay, so a lot of custom tradition is there. So this cannot be touched. Oh my God. Oh my God. Oh my God. Any unencumbered LIC pension plan taken in the name of the debtor or his immediate, okay, NPS, pension policy. Okay. Okay. Life insurance policy, pension plan taken in the name. Okay. Life insurance. Now, life insurance pension plan. So PPF, anyhow, PPF, as per the act of the PPF itself, you cannot attach it. Okay, you have a PPF rules are there. I want to show you that. So therefore, you need not mention it here. So if you go to PPF rules are there. This is PPF. So under this PPF rules, this is public provident fund scheme. Under the scheme itself, it is mentioned that you cannot attach. Okay. So discontinuation of account, interest, loans, and withdrawal from account, closure of the account, extension of the account, premature closure, protection from attachment. Look at this. Amount standing to the credit of any account holder shall not be liable to attachment under any decree, any order of any court, in respect of any debt or any liability incurred by the account holder, matter of PPF. That is, it is not mentioned there. So, Govinda, PPF is also gone. NPS is also gone. Land and building equity. So, excluded assets. An unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. Oh. Now single dwelling unit. This is my only property. This also to be excluded. But such value as may be prescribed. Prescribed. Where it is prescribed? Rules. Specified means regulation. Prescribed means rules. Okay. So now I'll go to the rules. This is rules. For the purpose of 79(4), the value of the unencumbered personal ornament shall not exceed 1 lakh rupees. Okay, C. Where is C? Any unencumbered personal or such well as may be prescribed. Okay. So, how much jewelry gifted? Oh, let me take it as lakhs. Lakhs. So now, out of this 15 lakhs, okay, I cannot exclude 15. How much I will exclude? I will only exclude 1 lakh. This is a case study, what I am doing. Okay. The value of the unencumbered single dwelling unit shall not exceed 20 lakhs if it is in urban area. Okay. The value unencumbered owned shall not exceed 20 lakhs. If it exceeds 20 lakhs, it can be included. Okay, please understand. So that is why you must always have a property which is small property up to 20 lakhs. 10 lakhs. Maybe 20 lakhs, 10 lakhs and all very small. Okay, maybe outer only you will take only one room you will get. Okay, what to do? This is what is mentioned here. Okay, so now you have to exclude all this. Okay, so a car, number 1, 2-wheeler. Okay, PPF. Then pension scheme you can exclude. Books you can exclude. Furniture you can exclude. Okay, and 15 lakhs. Okay, minus 14. Okay, 1 lakh is 1 lakh only you can exclude. Okay, so only 1 lakh only you can exclude. This is what you can exclude from net worth. So then what is to be included? 84 only. But I have given a guarantee for 120. You can only recover 84 from it, not more than that. Okay, so because land and building, equity plus jewelry. So 55 plus 15. So which is actually 70. 70 plus 14 jewelry. So 84. That only you can recover. Okay. That's all. Very, very important case. So this is your excluded assets. Now come to this question. Excluded assets include any unencumbered personal ornaments of such value not exceeding, ornaments means 1 lakh. So 29A. Excluded assets include unencumbered single dwelling unit. Urban area means 20 lakhs. So D. If it is a rural area means 10 lakhs. Rural area means, rural area means 10 lakhs. Okay. So it is urban area 20 lakhs. Rural area means 10 lakhs. So 31C. Okay. Very, very important question. Check. Now, let me take you to the next question. So, any question, guys, up to this? Anybody who want to raise any queries? Can raise your hand. Anybody who wish to raise any questions? Can I proceed? Mr. Tavinder Singh Ji.
Yes, sir. Sir, good morning, sir.
Very good morning, sir.
Yes, sir. It is very nice. You are taking up. I would like to you to explain the excluded debts also, sir. Excluded debts. That also is to be explained.
Oh, okay. Right. So one by one. So hope I am clear up to this.
Okay.
Right.
Yes, sir. Very nice going on, sir.
Thank you. Right. So now let us go to the next question. So this is excluded assets. Okay. Now let me now take you to the question called excluded debt. Okay. Now where this concept will come. Okay, excluded debt concept. So as I go, I'll try to unravel the mystery behind this excluded debt also. Okay. So now let me take you to those questions. So what I will do now, I will first take you to this questions one by one. So first I will take you to this 9. So we are in a section called, I want to bring to your attention. Yeah, this is the process I will tell you first. 94. This is step 1. I'll just give you the steps so that things are clear to all of you. What is step 1? In step 1, make an application. Now, who will make this application? Either debtor or creditor. Okay. So section is actually 94 or 95. So this we are clear. So where is it? This is here. 94 application by debtor to initiate, application by creditor to initiate. Step 1. Now after this, what will happen? Okay. When an application is filed under 94, an interim moratorium starts. Okay. Where the application has been made in relation to the firm, interim moratorium shall operate against all the parties. So the application, when it is accepted, interim moratorium starts. So let me put step 2. This is your interim moratorium. Okay. So this is your section 96. Right. So now, let me take you to the next one. Step 3. Now what is step 3? Please look at step 3. Appointment of RP. This is step 3. Actual, you have not passed, there is no order has been passed so far. So, I'll just come to that. This is appointment of RP. Okay, so 97. Now, why he is appointed? That is very important. If application 94 is filed through an RP, adjudicator shall direct the board within 7 days to confirm there is no disciplinary proceeding. So, see, either 94 can be filed by an RP or 95 can be filed by an RP on behalf of the debtor or the creditor. So then he himself will be appointed as a RP and he will confirm the appointment of the resolution professional. Now, order is not passed at all. The insolvency resolution process order is not passed. Application is not admitted. Before admission itself, RP is appointed. Please understand. Okay. So where an application is filed by debtor or creditor, not through RP, AA shall get the list and he will appoint. And AA by order appoint RP, recommended or nominated. The RP appointed by AA shall provide a copy of the application, shall be provided for insolvency resolution process. Okay. So what has been application that has been filed by 94 or 95? Okay, good. So this is appointment of an RP. Now, who will appoint RP? Okay, AA will appoint RP. Now, what is step 4? So actually, still insolvency resolution hasn't started. So you understand this process, then questions will be easy. Now, after this appointment, okay, after this appointment, of course, replacement RP can be done. That in between you are not comfortable, you can replace. That process is very similar to your previous process also, because still insolvency has not started. Now, if the debtor or creditor they want to replace, they may replace. It is possible. Okay. So it can be rejected also. So that process is given. This is a very, very important step. So I will not go to this replacement, which is if required, it can be done. Submission of report by RP. Okay. This is submission of report by RP. Why he is appointed? See, there is an application filed. It should be admitted. So before application and admission, RP is appointed and a report has to be filed. Now this report, okay, he will, what he will give in his report, please? Will he verify anything? The application, please understand this, he will examine the application. Okay. And RP shall examine the application and ascertain the application satisfies the requirement in 94 or 90. What is the requirement? Whether he is a debtor, whether he is a creditor, whether the individual, whether the personal guarantor has defaulted, whether they have initiated, whether they have invoked the guarantee, and when the guarantee was invoked, when he was sent the notice, did he respond to the notice? So he will not verify, he will only examine the application as per. So after examination, he may recommend. So look at this wording. It is called examination of the application. It is not verification. For the purpose of examining, RB may seek further explanation with respect to the application as required by the debtor in the opinion of the result as may be required. Now all this he should do it within 10 days. That is a RP within 10 days shall submit a report. Practically, whether it happens within 10 days is the next question. I will not answer now because that's a practical part of it. But as per the law, you have to submit the report within 10 days of your appointment. How practical it is a secondary part. Okay. Now, the resolution professional shall give a copy of the report to the debtor or creditor as the case may be. The resolution professional shall record the reasons for recommending the accepting or rejecting the application. And the RP shall give a copy of the report to the debtor or creditor as the case. Now, who is the debtor? Applicant. Who is the creditor? Applicant. Okay, so he will not give copy to both. For example, if a creditor is an applicant, the report will be given to adjudicating authority and a copy will be given to the creditor. If the applicant is a debtor, the report will be given to the adjudicating authority, copy to the debtor. Okay. So this is a very, very important step. So what is step 4? Submission of report by RP. This is 99. Now after this, only we have the step 5. Okay. So what is step 5? Admission or rejection of application. So let us say admission or rejection. Admission of application. This is the main step, 100. So I will not go to the rejection part. The rejection means step with this step, everything is over. Now after admission, what will happen? Okay. After admission, moratorium starts. Okay. So we will have this step. Okay, this is step 6. Moratorium starts. So 101. Now moratorium will be for 180 days. Now 180 days, what he will do? Okay. Here, this public notice, claim from creditors. This step is similar to your insolvency process. Okay. So I have some questions on this, but it will be very simple. Okay, look at this. This up to 5 we did. Now look at this. Public notice for claims under individuals shall call for claims on all creditors in and within the timeline. Okay, now look at this. The notice shall be in one English newspaper, one vernacular newspaper, and affixed in the premises, placed on the website. Now, how many days? Adjudicating authority shall issue a public notice within 7 days of passing of the order, inviting claims on all creditors within 21 days of such issue. Okay. Now, please note this. Public notice and claim from creditors. Adjudicating authority shall issue public notice. See, there is a lot of difference between your, look at this. Persons entitled, disposal of application, time limit, declaration of moratorium and public announcement. Adjudicating authority after admission shall by order declare a moratorium, cause a public announcement of the initiation of CARP and call for the submission of claims. Actually, the word is called cause a public announcement. Actually, adjudicating authority shall by order cause a public announcement. So far, in their website, it will be there. The order will be there. But in the regulation, okay, appoint an ARP in the manner as the public announcement refer shall be made immediately after appointment of ARP. Now, who will make this public announcement? It is not given here. It is given in the regulation. So IBBA regulation, they made it very clear. So CARP makes it clear. So I'll just take you to CARP. This is your CARP regulation. Who will make the public announcement? Eligibility, access to books, choice, extra, public announcement. And IP shall make a public announcement immediately on his appointment as an EM. Look at this difference, subtle difference. But come here, come here, come here. So here, this is, I'm sorry, where is it? Declaration of moratorium. I should go here. Moratorium. Public notice. AA shall issue a public notice. Please understand the fundamental difference between this part and that part. Okay. I'm sorry. Where is it? IP shall make a public announcement. Public announcement shall be in so and so form. The claim will be made. But here it is not so. Adjudicating authority shall issue a public notice. Within 7 days of passing the order under section 100, inviting claims on all creditors within 21 days of such issue. Okay, good. The notice shall include details of the order admitting the application. Actually, now what the AA will do, he will only post it in the website, shall issue a public notice. That's all. Beyond this, nothing has been mentioned here. But look at point number 3. Okay. The notice shall be published in one English newspaper, affixed in the premise adjudicating authority, placed on the website. So all the 3. So this will be all 3. Is it only in website? It is not only in website or AA. It will also be published. It will also be affixed in the NCLT, what is called, whether Chennai or Jaipur or wherever it is. It will be affixed in their office and in the newspaper also it will come. So the AA shall issue a public notice. Here the responsibility is with respect to AA, not with outsiders. So this is a place where I think this is a very, very important, I will say, a good practice. So if the court is going to publish, there will be a cost involved. And the people have to pay the cost too. So compared to the CIRP, it is the IP only has to make, and he has to pay from his pocket or he has to collect from the company. So this is a lot of difference between this method and that method. I will say this method is quite effective method. Okay, compared to the CIRP method. Okay, so there is, they ask a lot of revamping in CIRP. Yeah, we need not revamp. The part 3 is very good actually. The good practices which is there in part 3, let them implement in part 2. Okay, so that is sufficient. There are many good practices are here in part 3. I am telling you. Okay. So look at this. Public notice for claims under the individuals and partnership shall call for claims on all creditors in at least one English newspaper in circulation in the state 21 days, within the time of 21 days. So now, how many days they have mentioned here? Okay. All within 21 days of such issue. Okay. One English and one vernacular. At least one English in circulation in the state, 14 days around. 14 days is around, 14 days is around. 21 days is correct. One English in 21 days, one English, one vernacular in 21. So B is correct. So 6B is correct. Come to the last one. The public notice for claims under the individual partnership, I will ignore, shall contain details of what? Okay. Now come to this too. This notice will contain details of the order, particulars of the RP, last date for submission. These 3 alone will be there. Okay. It says except. Debt due from debtor, no. Details of the order will be there. Last date of claim will be there. Particulars of the RP, who's the name of the RP, Gopal, Krishna, Raju, name of the RP, his number, email, and everything will be there. So 7A is wrong. Okay. How much debt is due by debtor? How can we say? After only getting the claim, only we'll verify. Okay. Good. Now 8. Now we are in step number 6. Okay, moratorium. After that, step 7. This is public announcement. Then notice inviting claims. So now, creditors responding to the public notice for claims under the individuals and partnership individual insolvency resolution process shall respond by how they will respond. So look at the creditors will respond by email, courier, speed post, or register letter. Anyone. Actually, these things are already there. Same repeat. Okay. Email, courier, speed post, register post. So 8D. Now, up to this step is fine. Public announcement. Now come to step 8. After public announcement, you get everything. RP shall prepare list of creditors. Now come to this preparation of list of creditors. RP shall prepare list of creditors on the basis of information disclosed, claims received. Now, actually, you have something called as verification of claims. Okay. Now, only after the verification preparation, the list of creditors has to be prepared. So here, whether there is a concept called verification, there is no such concept called verification. Because, please understand one thing, RP has already given a report. Okay, RP has already given a report. Okay, so therefore, preparation of the list of creditors, RP shall prepare the list of creditors, information disclosed in application filed by debtor or creditor. Okay, so similarly, claims received based on both. Sometimes in application, 7 creditors will be there, but claim will come from 10 creditors. So it will be, list will be prepared. Okay. So the resolution professional shall prepare the list within 30 days from the date of notice. Okay. So now list of creditors. So there is no word called verification. Okay, please understand this word. So 104. This is 30 days. Public announcement. And here 21 days. Okay, good. So now list of creditors is prepared. Resolution professional shall prepare list of creditors based on books and records of debtor. No. Information of the application of the debtor and claims received. Both. So it is 9B. So on the application as well as claims, both will be compared and the list is prepared. Now whether verification will be done, whether that word is there, that word verification is there. Actually, no. That word verification is not. So that means the resolution professional will not do verification of creditors, but we have Mr. Tavinder Pal Singh as a question.
Sir, I would like to draw your attention to one thing, that the regulation 7 is saying that the verification of claim is to be done.
Yes, that is why that is personal guarantor.
Okay.
So thank you very much. So I thought somebody will say you are only mentioning about the code, not about the regulation, because this verification in CIRP also you have. Look at this word CIRP. This is where CIRP. So public announcement, claims by operational creditor, claim, substantiation of claim, cost of submission of proof of claim, and verification of claim. This is CIRP. Now come to IBBI. This is where IBBI bankruptcy process. This is your rules. This is your IBBI insolvency resolution process for personal guarantor. So here I'll take you to, because this is actually a 10-page eligibility of an RP, preservation record, debt counseling, submission and verification of claims. So here a creditor shall submit its claim along with the proof on or before the last date mentioned. So these steps will be very similar to your CIRP. Okay. So your submission and verification of claims is not mentioned in section, but it is mentioned in the regulation and very similar to your CIRP process. And after verification only, the list has to be prepared. So all these are very similar. So now I'll go to the next step. So information applied. So 9B. Come to the 10th question. The resolution professional shall consolidate claims. Okay, within how many days of public notice? So just now we saw that. Okay, it is within 30 days. Okay, so it is 10B. Good. Now come to the repayment plan. So this is your preparation of the repayment plan. So there you will have resolution plan. So list of creditors, I must say, after verification. Okay. Now, verification is not discussed in court, but discussed in regulations, not in rules. So 9. So here, repayment plan. So this is your 105. Now, repayment plan, who prepares it? See, normally, resolution plan means there is an advertisement, Form G, invite, RFP, all this stuff is there. So, these process will be absent here. So, the debtor shall prepare in consultation with the RP a repayment plan containing a proposal to the creditor. Restructuring is. So, it's very simple, straightforward. Okay. Straight away, he gives a plan. This is what is my assets are there. I will now present my plan for repayment. If it is acceptable, because there will be haircut in it, he'll say this is what is possible for. So the debtor shall prepare. So there is no outsiders giving getting an RFP advertisement calling for it. Why? Why there is an advertisement? It's my personal guarantor, I have given guarantee. So who will come for my rescue? So I should only come for my rescue. Okay. So the debtor shall prepare in consultation with the RP a repayment plan containing a proposal. Now come to 105. A repayment plan shall be prepared by whom? Debtor, containing a proposal to the creditor of restructuring of the debtor. Debtor in consultation with the resolution professional. Okay. The debtor in consultation resolution professional, a repayment plan containing a proposal for restructuring of its debtors. That will be given. Okay. So this is in 105.1. Good. This is 105.1. Good. So this is 11C. Good. So now come to the next one. The repayment plan shall include the following, namely, now coming for a very important question. So what this repayment plan will include? The repayment plan shall include justification, provision for payment of fees to resolution professional. This is actually this should be first. Okay. Such other matter as may specify. Justification for preparation of the repayment plan. Why 60% haircut is given? Why 40% is only paid? Why you are seeking for the discount of 60%? And reasons on the basis of which creditors may agree. So I have to give reasons. 1 page, 2 page, 3 page. I have to create a story. So I have to build a story, which based on the facts, that story has to be communicated. Okay. So the repayment plan shall include this following: justification, reasons, provision for payment in respect of debt for unliquidated amount. Actually, unliquidated amount is not crystallized. For example, there is something which you have been constructing. It is incomplete. Now, how much money you have to pay? Okay, because somebody has actually is a contractor. He has already made some construction. So it is called unliquidated amount. Unliquidated means it is unfinished. So on what basis you will raise up the invoice? How you will fix that figure? So the repayment plan shall it include a provision for payment of unliquidated? Provision means already partly done. Now whether there will be a provision for that? No, it is not there. So there is no concept called provision. There is no concept called provision for payment of fee. That will be there. Provision for payment of fee to RP will be there. Reasons has to be there. Justification has to be done. But unliquidated amount not crystallized. Let him raise an invoice. Okay, during the claim, let him raise an invoice. That means it is crystallized, not unliquidated. So 12C. 12C is not your answer. Okay. Now, in your question, repayment plan. Okay. Now, step 10. This repayment plan has to be accepted. Okay. Good. So let me come to this. Now, this is a meeting of creditors. Now, in this creditors meeting, everybody will be there. Financial creditor, operational creditor, everybody will be there. So, the resolution professional shall issue notice calling the meeting of the creditors, and it will be, he shall send the notice to the list of creditors prepared. So, they don't distinguish here between FC and OC, all this stuff. Everybody are creditors. And if the meeting of the creditors held under 108, then the RP shall send the notice to whom? Okay. So RP shall, meeting of the creditors is conducted. The creditors may decide to approve or modify. So the resolution professional shall ensure the modification suggested, obtain such modification. The resolution may for sufficient adjourn the meeting. So all this. Now, to whom the notice will be sent? The resolution will send the notice to financial creditors only. All creditors present in the list compiled by the resolution professional. Operation creditors only. Top creditors only by 80%. Okay, that is what is given here. Shall issue notice calling for the meeting. Shall send the notice to the list of creditors prepared under 104. The list of creditors after verification. Okay. So all creditors present in the list compiled by the resolution profession. Okay. So this is a list of creditors prepared. So I will not use the word compiled. List of all creditors present in the list prepared by the resolution profession. Okay. So 13B. Good. So now this is a very, very important question. How about a secured creditor? Okay. So let me take you to 110. So rights of a secured creditor in relation to repayment plan. So actually this is very similar to your secured creditor. Can he, because he has an asset, he has a security interest. So can he take a call to take care of himself? Okay, I will not submit a claim. So then what is his right? Okay, very important, very important. Okay. So secured creditor shall be entitled to participate and vote in the meeting of the creditors. Oh, can he participate? Yes. A secured creditor participating in the meeting and voting relation to repayment plan. See, secured creditor shall be entitled to participate and vote in the meeting of the creditor. Normal creditors meeting. But repayment plan, please understand the difference between creditors meeting, right to secured creditors in relation to repayment plan. Now come to this. Voting rights and meeting of the creditors. Conduct of meeting of the creditors. Okay. Summoning the meeting of the creditors. Now, in the creditors meeting, repayment plan will be submitted. Statement of affairs of the debtors, balance sheet will be submitted. Now, whether secured creditor can come? Yes. Secured creditor can be present? Yes. Now, can the secured creditor be entitled to participate and vote? Yes. But with respect to repayment plan, very important. So the moment when repayment plan voting is coming, secured creditor participating voting in repayment plan in relation shall forfeit his right to enforce the security during the period of the repayment in accordance with the terms of the repayment plan. Okay, please understand. A secured creditor participating in the meeting of the creditor and voting in relation to repayment plan, if he wants to vote for or against the repayment plan, he wants to vote for repayment plan, then he should forfeit his right to enforce the security during the period of the repayment plan in accordance with the terms of the repayment. You forfeit your right. Give that asset to me. Whatever money you want, we will pay. Otherwise, on repayment plan, you don't have a right to vote. So, when a secured creditor does not forfeit, he shall submit an affidavit to the resolution professional, the meeting, stating the right to vote exercised by secured creditors only in respect to unsecured part of the debt and the estimated part of the unsecured part of the debt. Now, for example, the total debt is 40 lakhs. Security is 15 lakhs. 40 lakhs is debt, security is 15 lakhs. He will say, out of 40 lakhs, 15 lakhs is secured. Remaining 25 lakhs, I have a right on repayment plan. So 2 and 3, please understand, very important. Now on the entire amount he wants to, entire repayment plan, he wants a right, means that 15 lakhs security interest he has to forfeit. Okay. No, on the unsecured portion only I will do it. Means he need to estimate the value of the unsecured part and an affidavit has to be given. My total loan amount is this. The security interest estimated amount is this. Normally, then what he will do, he will estimate the security amount less. This is very important point. Okay, so the estimated value of the security, so valuation is required. Then he will give an affidavit. Based on that only he can give a vote. Okay. To that extent only his voting rights will be there. A secured creditor of a non-corporate bank participant in the meeting of the creditor shall never vote, be entitled to participate and retain his right to enforce the security interest. Be entitled to participate and vote and retain his right to enforce the security interest. Be entitled to participate and vote, but shall forfeit his right to enforce security interest in respect of his secured. Which is the right one? He shall never vote is wrong. Okay. Be entitled to participate and retain his right to enforce security interest. This is also not correct. He has the right to either enforce the security. Now the question is, participating in the meeting of creditors, how he will participate with respect to voting on the repayment plan. That is where the question is. Be entitled to participate and vote. Vote means for resolution, repayment plan, and retain his right to enforce the security interest. If he is retaining the right to security interest, he cannot vote. So C is wrong. He is entitled to participate and retain his right to security interest. That is also wrong. Okay. So B and C are same, and entitled to participate and retain his right. He can participate and retain his right only to the extent the balance portion which is unsecured. That has to be mentioned. Be entitled to participate and vote, but shall forfeit his right to enforce. Then he can vote. So D is correct. Okay. D is mentioned in your part, subsection 2. Then a secured creditor of a non-corporate person participating in a meeting does not forfeit his right to enforcement. Then what will happen? If it does not forfeit, always forfeit right to vote, wrong. He can never participate is also wrong. Provided submits an affidavit that his participation or voting of his unsecured debt and the estimated value of such debt is disclosed. Very important. He is only participating for the unsecured portion. 40 lakhs, 15 lakhs is secured, 25 lakhs is unsecured. I am only voting for the 25 lakhs. So who are all the creditors? What is the 25 lakhs of the total? That percentage vote only he will have. So total unsecured total creditors is 150 lakhs. 25 lakhs is his share. 25 out of 150. That is the percentage of what he will have. Security interest he is not forfeiting. So he cannot vote on. His vote will be restricted. His percentage of vote will be restricted to that extent. Provided he submits an affidavit that his participation voting pertains to his unsecured debts. So does not forfeit. Provided he submits an affidavit to the unsecured debt and the estimated value. So D and C both are same. But the estimated value of debt is disclosed. Okay. So C is your answer, 15C. Good. Right. Now, I'll now take you to another interesting question, which will form part of your section. This is onerous property. Okay. Whenever you have a onerous property, what is this mean called onerous property? So that means this property will fetch you some value. Okay. Actually, this will come in bankruptcy. So I have to take you to bankruptcy, then I'll take you to this onerous part. Now, let me take you to this bankruptcy. Okay, the insolvency professional shall be, actually when bankruptcy will come, I'll make this point clear. Okay, look at this. So when can a bankruptcy order not be issued by the adjudicating authority? Okay, look at this. So I just want to share with you 4 sections. Okay, look at section 104. So now I think majority part is clear to you. So look at section 100 subclass 4. What is 100? Admission or rejection. This rejection, I'm coming for a very important step. Look at rejection. If your application is rejected, if the application is rejected on the basis of report of RP, RP says many things are wrong. He is actually fooling the creditors. So therefore, application will be rejected. Then how the creditors will take money from them? That the application was made with the intent to defraud creditors or the resolution professional. The order shall be, the order under subsection shall record the creditor entitled to file a bankruptcy order under chapter 4. So now, insolvency is not possible because he is defrauding creditors. So, if the application itself is rejected, bankruptcy application can be filed against the. Now, bankruptcy is filed. That's all. The bankruptcy trustee will, all the assets of the debtor will vest with the bankruptcy trustee, and he will start liquidating. He will start selling the assets, recovering the amount, pay the creditors, and give the list to the the adjudicating authority, and then a discharge order. Okay, now everything whatever realized has been paid, balance is write-off. Balance is write-off. There is a waterfall model is there. So very similar to section 54, we have a waterfall model. So I'll come to that waterfall model also. So this is 104. Now there is one more section called 115. Look at 115. The effect of order of adjudicating authority and repayment plan. Now, look at this too, where the adjudicating authority rejects the repayment plan. Okay, repayment plan, the debtor and the creditor shall be entitled. Now, why the adjudicating authority rejects the resolution plan, repayment plan? Okay, now there can be various reasons. For example, the repayment plan is not subject to the conditions that has been mentioned. Okay, so what are the order of the adjudicating authority on repayment plan? So especially repayment plan should stick on to certain conditions. We just now saw those conditions. Okay, what are those conditions? So you must give the reasons why you are giving a repayment plan like this, and on what time you will actually make the payment. Now all these are there, but where is the assets? From where you will make the payment? So that is why I gave the list here. I said I have a net worth so big, so much big net worth is there, 135. I given a guarantee for 120. Excluded is this 84. Now how much you will pay out of 120? Only 84 only you will pay. Okay, because you have to say these are all excluded. How can I cannot give this money to you? So only this can be diluted, and I will sell this and I will pay. I need time. 30 days time I will sell and I will pay. So now sometimes if it takes time, it is land and building 55 lakhs. So if it is not realizable, you have to say how you will realize this 55. Equity you can sell it immediately, but land and building, do you have an immediate party to sell? So if you say no, I will pay within 30 days, how realistic is it? What is the reasoning you have to give in the whatever? Otherwise, the repayment plan will be rejected. Okay. So now come to this section, order of the repayment plan. If it is rejected, debtors and creditors entitled to file bankruptcy order, bankruptcy application. So this is second. So application itself is rejected. Repayment plan rejected. Okay. Then we have repayment plan ends prematurely. That means certain points are not satisfied. Look at this. Adjudicating authority shall pass an order and base a report submitted by RP that the repayment plan has not been completely implemented. So it is only a repayment plan, not practically possible. So then it is defrauding creditors. Then the debtor or creditor can file a bankruptcy application. So please understand, at the application stage rejected, bankruptcy can be filed. Repayment plan not possible to implement, application can be filed for bankruptcy. During the implementation of the repayment plan, not satisfied, then bankruptcy can be filed. So look at all the options. There is one more options, that is 121. So an application for bankruptcy may be made by a creditor individually or jointly to the adjudicating under the following circumstances. These are the three sections: 104, 115 to 118.3. Now look at this. When can a bankruptcy order not be issued by the adjudicating authority? When the repayment plan is rejected by the adjudicating authority, when the repayment plan has a premature closure and some creditors have not been paid, when repayment plan has been completely accomplished fully, bankruptcy order cannot be. If it is accomplished, it's perfect. So 19B is you cannot go for a bankruptcy. Application preferred by debtors to defraud creditors, that is rejected. Application itself is rejected. So this is your bankruptcy order. Now I will now take you to the insolvency professional shall be appointed by the bankruptcy as the bankruptcy trustee by the adjudicating authority. Now look at 125.5. So his name is called now bankruptcy trustee. The bankruptcy trustee confirmed or nominated shall be appointed as the bankruptcy trustee by the adjudicating authority in the bankruptcy order. Okay, he is a bankruptcy trustee, 21A. Okay, good. Now, I'll now take you to this onerous question. What is called onerous? Now, when the bankruptcy process is going, okay, the bankruptcy order is passed, debtor will be called as bankrupt. The insolvency professional is called as bankruptcy trustee. Okay, and there are estate. Okay, his estate, what will be called as a bankruptcy estate. So that is a place where excluded debt will come. That is a place where excluded debt will come. So Mr. Tavinderji took a point there. Okay. Now here there are certain assets which are onerous property. What do you mean by onerous property? Asset will be 50 lakhs, but the liability on that asset will be 60 lakhs. Will you realize it and pay 10 lakhs excess? No. It's an unprofitable contract, a property where the unsaleable or is not readily saleable, or it will give rise to your cost. That is called onerous property. So sometimes somebody introduced his wife, okay, to his friend. She is my wife, she is the owner of this property. Because she is the owner of the house property. And she also said, she is my onerous property. So this fellow didn't understood what is onerous property. So because one side she is an asset, and other side her liability is greater than the real worth. Okay, so that is the indirectly he is mentioning in such a terminology. So onerous property means asset, but the value of the liability is greater than the asset value. Okay, so guys, I am sure by this time you would have understood the significance of the size of this subject, especially part 3. I will now open the forum for any questions. Any queries are there, I'll be open to answer questions. So Vishal Singh, Tejas Gandhi, Sumit Rangta, Sandeep Singh, Lakshmanan Ramanathan. Yeah, Tavinderji. Yes, Tavinderji. Please go ahead.
Yes, sir. Good morning, sir. I always admire listening you. You are very, scientific and technical approach to explain the things with all the rules and regulations and so many things you open on the same screen and explain it. It is very nice. Sir, I would like to know one thing that when this dwelling unit we are talking about for the rural area is 10 lakhs and for the urban area it is 20 lakhs. Now suppose the property is 55 lakhs. So shall we exclude this 10 or 20 from 55, or then it will not be considered? Same is for the jewelry. You have a jewelry of 15 lakhs. For religious purpose, we are taking 1 lakh. So we should take 14 or all 15. Please clarify.
Okay, so the wording that is used there is the value of the unencumbered personal ornaments shall not exceed 1 lakh rupees. Okay, shall not exceed 1 lakh rupees. Now, if it exceeds 1 lakh, okay, I repeat, if it exceeds 1 lakh, can I take 1 lakh as a basic exemption is the question. I intentionally did this part. And in my example, you would have noted that land and building, I didn't subtract 20 lakhs, but in jewelry, I subtracted 1 lakh. Okay, in jewelry, I subtracted 1 lakh. Why I did that? Okay, so they will give you an option. See, normally it will be possible that you will have some traditional jewelries or family jewelries, but the land and building is only one item. You cannot bit it into pieces. But jewelry, there will be a lot of bits and pieces. 17 items, 23 items, 40 items. So in that, you can identify which 1 lakh. Within 1 lakh, you can identify. So that is why I subtracted 1 lakh from the 15 lakhs jewelry, because jewelry is not one piece. Jewelry is multiple pieces. So I can identify 1 lakh. This is my personal property. So anything beyond 1 lakh, it will not be excluded. So, but land and building, 20 lakhs and 30 lakhs, I cannot distinguish. So therefore, if it is above 20, it is entirely to be covered in the assets. If it is below 20, you can exclude. So that is why I took that liberty. So thank you very much for this question, Davinderji.
Thank you, sir. Thank you very much, sir. I salute you, sir, for the way you explain the things. Always, I love to listen to all your sessions. And Pune branch, I would like to thank. They have organized this very nice session. And especially most of us we are appearing for LA examination in the month of June itself. So it is a boon to us for our preparation. Hats off to you also.
Any other question? Yeah, we have Mr. Amit Rastogi. Mr. Amit Bhai, kindly introduce yourself and share your thoughts, please. Mr. Lakshman.
Sir, I am a CMA, and sir, we had an excellent session today. I need to ask one question, sir. While filing the application for CIRP, it states that Section 7 it needs to be filed jointly or either individually. So, if there are so many creditors, and there may be some creditors in respect to whom default is not. And or their condition, can they join hands with the ones for whom the payments are in default?
Sir, your question is with respect to CIRP or with personal guarantor?
Sir, CIRP.
Oh, CIRP. So this is with respect to operation creditor or financial creditor?
Financial creditor, sir.
Financial creditor. One financial creditor, can he apply, or jointly with another financial creditor, can he apply? That is your question?
Sir, further, there is one more question. Can he join hands with those creditors in regard to whom default has not been made?
Why not? It is one default is sufficient. One default is sufficient. The corporate debtor is a default. So while joining, the other creditors may, it is up to their discretion. They have to think, no, the company has not defaulted me. How can I sign the petition? This is a legal point. So I really appreciate your question. So when the application is signed by, or when the authorization is given by one financial creditor to the other financial creditor to apply, the argument will be from the company side. No, I am not defaulted to this financial creditor. I am surprised why he is a signatory. So then they have to cut a sorry figure before the court of law. My lord will ask, why you have been a signatory? So therefore, it is a legal point. So it's a practical question what you have raised. Thank you very much. So before signing the application, they should be very careful that why they should be a signatory, and unless and otherwise it is a default from their side also, they will join hands. Otherwise, not required.
Thank you, sir. Thank you.
Lakshmananji, good morning.
An excellent session by Dr. Raju Garu. I read many times of the owner's property actually, but many times I read, but in single line, when small example, you explained it. Hats off to you, sir. My sincere thanks. My special thanks also to the Pune branch. Well organized. Well done, Father, sir. Keep it up, sir. Keep it up. Keep it up, madam. Well done, Father. Thank you, Dr. Raju. Thank you, sir.
So anybody else who wish to share? Dilip Bhai, good morning.
I was about to ask if Sadbhai sir would like to join in. Dear all participants, I recognize the presence of our past chairperson, CA Dr. Dilip Sadbhai sir.
Good morning, Amruta. Good morning, Dr. GKR. It was a very pleasant and happy situation to hear you today also. And it is just like as the same that what we have been hearing since so many years in itself. So we are expecting your one more lecture on 6 cases which have been formulated by the LI for the LIE examination in itself. So I'm expecting Amruta also to look into the matter and have a association with Kolhapur branch and have a offline lecture for a full day of Dr. GKR. I'll be very happy to do that because we are in a process of gaining knowledge, and that is the most bigger hurdle that we are facing of learning 400 pages case so far as the case laws are concerned. So it's very difficult situation, but one case for 400 pages becomes difficult for us to read it out and find out what is the central idea in that. So many other cases are also there which are running into 50, 100, 200 pages in itself. So if you can compile those cases, and if you can segregate, these are the cases on liquidation, these are the cases on CIRP, these are the cases on individual cases. So in that case, we'll be able to divert our attention on those, and we can find out that what best possible solution we can have to get through the examination. So it is one step forward for me, because I'm still making up my mind to appear for the exam, but still I'm not sure that whether I'll be able to cope up with the situation or not. I have done certificate courses, I have done many other things, but still not very confident about appearing for the examination, only for the reason that what type of questions are likely to be asked, even though I have read it out around 5,000, 6,000 questions, but not sure whether the same questions would appear in the final examination. So I'm trying now in the next 3 months of time, as soon as your lecture will be off, and then we will see that whether results ultimately are coming up to expectation or not. I must thank Rajesh, the chairman of the Pune branch, the very efficient Amruta, the vice chairperson of the Pune branch, and to you, sir, also for dedicated efforts for making us knowledge enriched in this LIE. Thank you.
Thank
Thank
you.
you, sir.
So then it's up to Vice Chairperson. We have Pallavi Agarwal from Lucknow, Deepali Nigam. Any points they want to share?
Thank you, sir. Thank you for a wonderful session. It's always pleasure to listening to you, sir. We get so much takeaway.
Thank you very much, madam.
Thank you, sir.
So over to Vice Chairperson.
So a big thank you, sincere gratitude on behalf of the entire organizing team here at the Pune branch and on behalf of the participants for all your time and valuable guidance, not only in this session, but all the support and help in designing such a wonderful program structure and help us get the excellent faculties throughout India. I really thank you on behalf of the entire organizing team for one reason, that despite of our busy schedules, early mornings you have kept these slots so that it is convenient for all the participants as well. So thoughtful of you, sir. Thank you very much for the same.
Thank you very much. Thank you.
Thank you so much. All the participants, wishing you all the very best for the upcoming exams. Sadbhai sir, thank you for wonderful suggestions and guidance as always. And the technical team support here at the Pune branch. Thanks for their technical support throughout the sessions the entire week. I appreciate all the time and efforts of all the faculties for the entire last week. Thank you so much. All the very best. Good day to everyone. Bye. Take care.